Okay, guys, so we will continue our discussion. Now, here we will discuss about the part 4 quickly, the directive principles. Okay, so directive principles of state policy. So, because of this directive, this is what actually mainly differentiating from this police state to welfare state. Okay, so the welfare state principles you can see, especially now, whatever is discussed in preamble. So, it will be mostly reflected in the directive principle. So this is basically to establish social and economic democracy. If you look into part 3, which among the following is establishing social and economic democracy? It is DPSP. Which among the following is for the political democracy? That is fundamental rights. This can also be a question. Political democracy related to fundamental rights, social democracy, economic democracy related to the DPSP. I've told you yesterday also, when we discuss about democracy, we will have to look at the 3 dimensions: social, economic, and political. Remember when we discussed about the concept of freedom, the true freedom is when you are free in all aspects, like social, economic, and political. So the political part is what have been dealt with fundamental rights, and these two are actually under DPSP. So mainly DPSP is related to the welfare, and this is what actually differentiating a police state and a welfare state. And guys, yesterday I've told you some of the one or two important DPSP. You, this is something which we cannot discuss. Like what I've told you, fundamental duty, they can also ask you which among the following are the directive principles. Okay, so you need to have a very clear idea, but it is impossible for you to mug it up. Not impossible, but it will be difficult. But you can categorize into 3, right? The liberal principles are there, and then the Gandhian principles are there, and then the socialistic principles are there. So like equal pay for equal work. Okay, so while looking into that, you will be able to understand. So they will categorically ask you which among the following are the Gandhian principles, or the directive principles, which is related to Gandhian thoughts or Gandhian principle, or the liberal, like uniform civil code. If you look into that, may be coming here, right? Equal pay for equal work and all will come here. So working conditions, that by seeing that you will be in a position to understand, and that's what actually required. So one thing is, directive principle, unlike the fundamental rights, these are not enforceable. Like when we discuss about preamble also, I've told you, fundamental duties also I've told you, the same way directive principles are not enforceable in court of law. But what about part 3, fundamental rights, enforceable, right? You have this article 32 itself is direct, right? So article 32 itself is your fundamental right, and under which you can directly go to Supreme Court for the enforceability of the fundamental rights if it is violated. Similarly, we have also discussed about article 13. Any laws which is made in violation of the fundamental rights will be declared as null and void. And there we have discussed about 13 clause 1, 13 clause 2, etc. And based on that, we have seen some of the cases and amendability of fundamental rights and everything that we have seen. So I hope you guys have good knowledge about that. If not, you need to refer to that, the cases that I've briefly mentioned yesterday. Look into the details of that. Okay, so directive principles of state policy cannot be enforced. Now, what is a case laws? Here, what can be the case law? Like a fundamental right versus DPSP, right? The state may try to come up with some policy to implement the DPSP. So it may affect the fundamental right. For example, when I have discussed about 39B, 39C, etc., what is that? This is connected to the material resources of the society should be distributed to all. So in that context only, you can go for land reforms and bank nationalization, abolition of privy purses, etc. Okay, so when you go with those kinds of legislation, it is actually affecting the fundamental right. So it will be challenged. Okay, so now there are different case laws that is talking about fundamental rights and DPSP. So the first case, ultimately, if you see, that is a Champagam Rajan. Champagam Rajan versus state. Okay, so state of Madras. So in this case, this is 1951. It has been held that actually DPs cannot override fundamental rights. So if there is a conflict between fundamental rights and DPs, who will survive? The fundamental rights will survive. Okay, so the fundamental right will prevail if there is a the conflict between these two. Then we have seen this case of Re-Kerala Education Bill case 1957. So here it has been held that there is no clear-cut distinction that you need to make in terms of superiority or inferiority. Both are required. In fact, both are actually complementary rather than you considering both as contradictory. These are like two sides of the same coin. Okay, so as much as possible, keep both of them together. So there is a principle of harmonic, harmonious construction, that principle of harmonious construction. Okay, so it should be like this: if the judges or if the court is looking into any case where the dispute between fundamental right and DPs are coming, you should try to interpret in such a way that there should not be any conflict, because both are equally required, both are complementary. So there should be a harmonic situation. That is the way court need to consider. However, in case still if there is any problem, okay, there are reasonable restrictions and all for fundamental rights also. So in fact, this DPs are actually relevant in understanding that reasonable restriction also with respect to the fundamental right. So still if there is any problem, who will be getting the priority? It should be the fundamental right which is going to prevail. So even in these two cases, ultimate understanding, if you look into the fundamental rights, has been given importance. Although in Re-Kerala case, the principle of harmonious mean or the construction was introduced, but still if there is any issue, this fundamental rights will survive. Okay. Then now the third case, like this only, there is a amendment like 25th amendment. Yesterday we talked about 24th amendment. So 25th amendment actually introduced article 31C. So under this article will read like this: if the state enact a law to give effect to two DPs under 39B and 39C. Okay, this land reforms and everything is coming under this. So if you need to give effect to these two directive principles, and you are making or enacting a law, in that context that laws are violating the fundamental rights, then it will not be declared as unconstitutional. So this is what this article 25 or the 25th constitutional amendment, which added this 31C. Okay, so guys, before that, this bank nationalization, privy purse abolition act, etc., which is held unconstitutional based on the previous judgment. So after that only this 25th amendment has been made, this article has been added. Okay, so anything that the parliament is making, that means any law which has been made by the parliament to fulfill this two criteria, this two directive principles, in that context, if there is a violation of the fundamental right, that cannot be declared as void. Okay, so with respect to this only, this Kesavananda case. So in Kesavananda case, yesterday in two situation we have discussed about that. In the amendability of fundamental rights we have discussed. With respect to preamble also we have discussed, right? Kesavananda Bharati. So Supreme Court held that 25th amendment is constitutionally valid. Okay, so now after this there is another amendment, that is 42nd amendment. So in 42nd amendment of 1976, among other things, the other important aspect of 42nd amendment, that yesterday also we have discussed few things and you will have to see that in detail. Among other things, this also amended this article 31C. Guys, I'm expecting most of you know about this, that's why we are going like this. Okay, so it actually amended this article 31C, and in the amended form it will read like this: the state can enact law, similar thing that we have discussed before, for implementing this. Earlier this only, right? What is 25th amendment act? State can pass a law for implementing this two, 39B, 39C. But now in the 42nd amendment it goes like this: it amended this one, 31C. So already what is 31C? It was introduced in 25th amendment for this particular article. Now the scope of 31C is widened by amending the 31C through the 42nd amendment act. How it is going? for giving effect to any DPs. Okay, and in that context, if it violates Article 19, 31, 14, etc., it will not be unconstitutional. But this has been this is how actually challenged in Minerva Mills case. In Minerva Mills case, why no audio? Is there any audio problem, guys? Is there any problem with audio? Others? No audio? Okay. So, are you with me so far? Like what we were talking about 25th Amendment and this connected to that, we have discussed about it has been held valid by the Supreme Court in the Kesavananda Bharati case. Okay. And then 42nd Amendment, what has been done? This very amendment itself has been changed or modified and adding all the directive principles. A state is passing any law to fulfill all the directive principles, and in that context, if there is a this 31 is related to right to property, right? This is freedom, like that. Okay. And 14 related to equality. So these three are widely contested, right? And in Minerva Mills case, it has been declared that the previous position, this one, for this two it is fine, but not for all. Okay, so there has to be a balance between part 3 and part 4. Now what is the balance? What is the current situation now? If you look into, to implement anything of these two, like 39B and 39C, then in that context, if you're violating this article, this fundamental rights like 19 and 14 and all, then there is no problem. Okay, except these two, it is not constitutional. So that is the current situation. So that has been clarified in the Minerva Mills case. And also they have amended in such a way that any directive principles can be fulfilled and the laws can be made. It will not be affecting, even if it is affecting the fundamental rights, that's not a problem, and there should not be any judicial review. So here only formally the Supreme Court has been held that judicial review is a basic feature. Even before that also, in previous case also, judicial review has been mentioned as the basic feature, but here it has been formally recognized that judicial review is actually the basic feature of the constitution. So that basic feature doctrine, it is actually getting evolved, and we have discussed about that yesterday also. So I hope the situation of DP is clear now. So can you so who is superior, fundamental right versus DP? DPs cannot be enforceable, fundamental right can be, is this should be, and this can be enforced, right? Under Article 32, 226, etc., that this can be enforced. But when it comes to this 39B and 39C, in that context only, you can go with the directive principles. Okay, just give me 1 minute, guys. Just 1 minute. Okay, so the main difference between DP and fundamental right, this is not enforceable, this is enforceable. Okay, so in fact DPs are positive in nature, fundamental rights are negative in nature. I mean, negatively worded, right? These are positive affirmations. The constitution is telling the states to do this, do this, do this. Okay, but here, don't do this, don't do this, don't, no, don't, not to discriminate. Okay, like that. This is what actually given in fundamental rights. So this is these are very general in nature, but these are very specific, and strict legal language is actually used. Okay, so I hope this is clear. So when it comes to fundamental rights, under Article 13 clause 1, 13 clause 2, in fact you can just learn this as 13. Any law which is made which is violating fundamental right, the court bound to declare it as illegal or unconstitutional. And DPs, no, right? And exception is 39B, 39C. So these are the key points. Now there can be a question even in prelims also, directives outside part 4. What are they? guys, this is something which you need to look into. I'll just write it down here. Just look into these articles. We don't have enough time to discuss now. 350A, then 351, 335. So these are the three. One more is there. Yeah, these are the three directives outside the part 4. Okay, so just look into this. It is related to this Hindi language and all those things. So you can expect a question from preamble, and then fundamental right, fundamental duty, DPSP, and in general other provisions that we have discussed with respect to written, unwritten, federal, unitary, based on that also. But here you can expect 2 or 3 questions from these 4 topic itself, guys. Okay. Now what we will do is we will quickly look into this emergency. 3 type of emergency. I'll try to spend 15 minutes and we'll try to explain that, and then president and vice president, and then we will move to parliament. Okay. So emergency. Which article? There are 3 types of emergency. So the national emergency 352, and the state emergency or the president rule you add 4 356, and then financial emergency, that is 360. So 3 emergency. Now 356, that is a national emergency. Guys, 1 minute. So this one can be imposed on what grounds? There should be a war, external aggression, or armed rebellion. No, doctrine of severability means like laws made, and in that some part is constitutional and some part is unconstitutional. Like this is not violating any fundamental rights, and this is violating the fundamental right. So in this law, whatever is violating the fundamental right, this one, no, this will be struck down and this will be valid. So that portion of the law which is not violating the fundamental rights will be valid. Doctrine of eclipse, yes, yeah, that I have discussed yesterday, Varsha. Okay, that case also we have discussed in detail. Now war, external aggression, and this one, armed rebellion. Okay, initially it was internal disturbance, and then guys, I'll talk about this amendment, 44th amendment. Some changes have been made with respect to approval and the written permission of cabinet and everything. In fact, the word cabinet was introduced in this context only. I'll come to that in the 44th amendment just in 2 minutes. Okay, so these are the grounds: the war, external aggression, and armed rebellion. Just remember this point. Before it was internal emergency, and it is why it is not internal emergency. Why it is replaced? Because anything can be internal emergency, so it can be widely misused, and in fact it is misused, and that's the reason why it has to be replaced with armed rebellion. Okay, so how many times? 1962 to 68 one was there, 71 to 77 during this Pakistan war, this is during the China war, and then 75 to 77. In fact, this one was in force already, then this also was introduced. Okay, so that is a third one. The grounds, who will do this? The president will do this. If the president is satisfied that the security of India is under threat, what are the 3 criteria? External aggression, war, and armed rebellion. So if president is satisfied, and guys, this president satisfaction means it is whose satisfaction? It is ultimately the cabinet satisfaction or the council of ministers satisfaction. Okay, so there has to be a written recommendation to the president, okay, from the cabinet, and then only he can go for proclamation of emergency. So it is actually proclaimed. So it will be proclaimed first, the president will proclaim, and then it will be approved later. Okay, so it has to be approved within how many times? Within how many months? Within 1 month. Okay, with a special majority. Okay, so special majority means like 2 by 3rd of the majority. Okay, so there has to be 2 by 3rd majority, and it has to be earlier. This was 1 month. No, earlier this was 2 months. Earlier, what is it? We don't want to look into. At present, it is 1 month. And what majority? Special majority. Earlier, 2 month, and simple majority. It is easy to get simple majority. At the same time, even if you are not getting, but still you are getting 2 months, it is your power, right? But that has been reduced now to 1 month. Okay. And then once it is approved, it will continue in operation for 6 months, and after 6 months the same process can be repeated. Okay, you need the permission from both the houses, and then it can be continued also. So guys, here this key word you need to remember: once it is approved, not once it is proclaimed or not imposed. Proclaimed or imposed, even when I discussed about last time about this also, you guys had the confusion, right? So once it is approved, it will be for 6 months. So even before approval, you can operate it for 1 month, right? So it can be like 7 months. I hope this point is clear. But when I discuss about state emergency or financial emergency, it will be like from it is proclaimed or from it is imposed. So there is a difference here. Here, once it is approved, it will continue in operation for 6 months. Okay. So after that similar manner, you need to do this. Now, how can it be withdrawn? Again, president is proclaiming, so president can go for a proclamation of revocation. That too, again, with the advice of Council of Minister. Okay. Then, with respect to this, the other way in which this will not continue, or is that after 6 months, if it is not passed in both the houses of parliament, then it will not continue. Okay, so the first way, how can you withdraw it? President can issue revocation. Second way, it is not passed in the parliament. Third way, actually, Lok Sabha, if you see, have a special power here. Consultation of Council of Ministers, cabinet is required. In fact, you just remember in this way, president for anything, he actually require the recommendation of the Council of Ministers, except few cases that is the discretion of president. If time was there when we discuss about president, I'll tell you. Even when you talk about suspensive veto, you don't want the recommendation. Okay, you can just refer it back. Similarly, pocket veto, you don't want the recommendation of the Council of Ministers. But if it is absolute veto, you need to act according to the Council of Ministers. But here and all, once you proclaim, you need the written recommendation of the cabinet. Even for revocation also, you are doing it with the advice of the Council of Minister. Okay, Lok Sabha have a special power for withdrawal of emergency. If there is a 10% of total members of Lok Sabha give a notice to the president, then after giving notice to the president, if the Lok Sabha is not in session, you can give it to the speaker also. Okay, and when the Lok Sabha is in session, then what will be done? There will be another sitting which will be held within 14 days of giving this notice. So 10% of the members of Lok Sabha have to give a notice to the president that they don't want to continue this national emergency. Then within 14 days, a session will be held, and then again we'll see the majority, and based on that only it will be continued. So here, if you look into, Lok Sabha have a special power with respect to the national emergency. Guys, then this executive, how those powers and everything is changing. In fact, if you look into the executive power, there will be a concurrent power, right? In those with respect to the state legislature, and the parliament can also enact on state list, like yesterday we have discussed about this. Okay. Financial effect, the financial relation or financial power which exists between center and state may cease to be in operation, because center can directly do certain things. Okay, now what is more important here is with respect to the fundamental rights. Okay, so under Article 358, just read this once the session is over. When the national emergency is declared on what grounds? War and external aggression. Then the fundamental rights under Article 19 automatically will get suspended. Okay, which case? War and external aggression. So this is related to war will be with external country only, right? Outside country only, and external aggression. So this is not internal. Okay, so in that case, automatically fundamental right, this one, 19, what is that? Right to freedom. You will not be allowed to go anywhere and talk anything, right? That is normal common sense. So 19 will automatically get suspended. Now you just read this also. 359, under article 359, except for this one, article 20 and 21, okay, the government can declare suspension of enforceability of any other fundamental rights. So what has been done here? Government can declare suspension of enforceability. Only if government declare suspension of enforceability, now you cannot go and challenge it in the Supreme Court. The fundamental rights is not gone. It is there, like 14, 15, and everything is there, but you cannot go to Supreme Court for the enforcement of this if under article 359, if the government suspended the enforceability. Okay. Now this one, the 44th amendment, quickly I'll discuss. This is very important when it comes to national emergency. But before that, this 42nd Amendment Act, that is in 1976, introduced the provision under 352 that national emergency can be imposed either throughout India or a specific part of India. So it can be like entire India, or if the problem is here, if the armed rebellion is here, or the external aggression is actually happening this area, there is no point in imposing at this area, right? So it can be specific region also. So that is there in the 42nd Amendment. 44th is very important, guys. They can ask you prelims as well as mains question, but mains we are not discussing anywhere at this point of time. 44th, if you see, president can impose national emergency only getting the recommendation or written recommendation of the cabinet, or cabinet should give in writing to the president, then only president can proclaim. In fact, this term cabinet is actually it is not originally there in the constitution, introduced for the first time here in the 44th Amendment. Okay. And internal disturbance is not a ground. Instead, instead of internal disturbance, what has been done? Changed or substituted with armed rebellion. Okay. And then I've told you already before, earlier it was 2 months approval, and with a simple majority, like you had enough flexibility here, but that has been changed to 1 month because of the misuse of national emergency during that time, and also special majority. But remember, earlier it was 2 months. That means even for state emergency as well as financial emergency, it was 2 months. Here also 2 months, and this is simple majority. This is also simple majority. This was the situation for national emergency also. But what has been done now? This 2 month has been changed to 1 month. The simple has been changed to special because it has been misused a lot. Okay, during that time. So these are some of the change. Then the one which I have discussed with respect to Article 19, the fundamental right under Article 19, the right to freedom can be suspended automatically. This is a word, guys. Only when, yes, both the houses of parliament. Only when, okay, what I was discussing here. Yeah, 19, this I think I have discussed this point already. Automatically only when if it is on the base of war or external aggression, right? In case of internal, no. Automatically it won't get suspended. Yeah. Okay. So I hope this is also one point within 44. Then article 20 and 21 cannot be suspended under any situation. 20 and 21 cannot be suspended. Okay. These are the key points that you need to remember with respect to 44th Amendment Act, which is related to national emergency. Now, president rule. So here, Article 355 makes it obligatory for the union government what to protect a state against any external aggression, internal disturbance, and to ensure that state in the government in the state is carried in accordance to the constitution. So it is the responsibility of the center or the union to ensure that the government or the governance in the state is carried in accordance with the constitution, and mechanisms to fulfill these conditions is actually given in the Article 356. So if the state government is not carried in accordance with the constitution, then the president rule can be imposed. This is what state emergency. So the key point here is, if there is a failure in the governance at the state level, then the president rule can be imposed. This failure can be, it is basically very subjective, but there are many grounds which has been made clear also by the Supreme Court in various judgments. You can see even secularism is also one of the ground, right? If the state is not able to implement any law which is connected to secularism, or if the state is passing a law which is against the principle of secularism, that also, yeah, Bombay case. Yesterday we have discussed about this. Parliament make law on state subject. Parliament can make law on state subject on national emergency and state emergency. But what is the difference? National emergency, it's a parallel power, concurrent power. The state, upon state list, Parliament can make law. State also can make law because state government is also present, right? And if there is a conflict, then the Parliament law will prevail. But in case of state emergency, what is actually happening? Why state emergency? Because the constitutional machineries in the state is not working properly. So what will happen? Immediately once the state emergency is declared, that council of minister is dissolved. No more council of minister is gone. Then there is a legislative assembly, right? This will be suspended. It will not be dissolved immediately. There are judgments with respect to this. It cannot be dissolved. You will look into the possibility of making other system and setup with this existing members, the member of state legislative assembly, MLAs. Okay, it will not be dissolved, it will be suspended. So council of ministers, the main executive body is gone. Okay, the legislature is suspended. So who will make law? Only Parliament can make law here. Okay, or president can make ordinances also. Okay. Now here, those things that we have discussed, you can discuss it already. Like once it is imposed, it will continue for 6 months, and once it is imposed, you need approval within 2 months, and with simple majority. These things are common in both financial emergency and state emergency or the president rule. Okay, so it will continue for 6 months. And now, if you need to extend it beyond 6 months or beyond one, after 6 months, you can follow the same procedure and you can extend it for another 6 months. So how much is over now? 1 year. But if you need to extend it beyond 1 year, there are two conditions. Okay, so beyond 1 year, two conditions, both has to be satisfied simultaneously. It's not that either or. What is the condition? There should be a national emergency which should be in operation throughout India or in that state, in part of that state. Okay, national emergency should be there. Then Election Commission of India should actually certify that the conditions in state are such a way that it is not conducive for holding the new fair elections, new free and fair election. Okay, so if these two conditions are satisfied, then it can be extended beyond 1 year. Otherwise, maximum is actually 1 year. In case of national emergency, it is 3 years. Here it is 1 year. Okay, so I hope this is clear. Financial emergency also, guys. Then what is the role of president? Judicial review is there, right? In fact, in all cases, judicial review is there. Even for national emergency, also judicial review is there. Okay, but the judicial review cannot be on the advice given by the council of minister. No. What is the advice given by the council of minister and all cannot be going for judicial review. But then what is the judicial review? The material facts behind the national emergency. So the judiciary can look into the material facts and can see whether it is malified, whether it is done with malified intention or any other such reason. Then the judiciary can interfere. Similarly, in president rule also, obviously what will happen, guys, in case of state emergency is imposed, what the state will do, what the council of ministers immediately will do, directly will approach the Supreme Court. Do you think that they will just leave it like that? No, right? So judicial review is there. Even here also subject to judicial review. Okay, so if you need to discuss about the Bombay case, (1994). So this power of Article 356, which is vested with the president, if the president is satisfied, that is a word, right? This is not absolute power. It is having some limitations, some restrictions. So when we discuss about the satisfaction of the president, it is ultimately the satisfaction of the Council of Minister, because president have to act in accordance with the aid and advice of the Council of Minister only, right? So in that context, you can say the president power is not absolute. This is not his conviction. It is all about the Council of Minister, the satisfaction of the Council of Minister, and this will be subjected to judicial review, but not the advice, the facts that leading to the material facts that leading to the imposition. So if the court find that this is irrelevant, this is malified, then can be declared as constitutional. Okay, and also it has been made clear that whatever govern, it has to be done on the report of the governor, right? The governor have to write a report to the president, or governor have to recommend the president that the constitutional machineries are failure and not working properly. So this report has to be a speaking document. What do you mean by speaking document? Every details why the constitutional machineries are not able to work, and everything has to be very clear. Okay. Again, this provision which I've already told you, dissolution, it is not done. It will be done only after some time, right? So no, I didn't get you, Rajashekhar. President can take upon his own means. Okay, now see, that is the case. Obviously this is a direct route. The governor is appointed by the president, so in case if there is any problem, governor will give the recommendation. President can take up his own also if there is a recommendation from the Council of Ministers. Yes. Okay. Okay, now with respect to this, the president, why this provision is there? It will be suspended only. What is the logic? What I've told you, Council of Ministers will be immediately dismissed, but the Legislative Assembly, MLAs will be, the legislature will be suspended time being. Why? Because whether this is correct or not, it has to be accepted, right? Within 2 months, it has to be accepted by both the houses. So once the acceptance is there, then you can dissolve the Legislative Assembly. Till then, it will be suspended. You will look for any other possibility also. Okay. One more thing, guys. If there is any issue which is happening in the state which is affecting the basic structure of the constitution or basic feature of the constitution, that is what I've told you. Secularism is one of the basic feature. In case of any such problem which is happening with respect to basic feature, then also that is also can be a ground of imposition of president rule. So what is the main difference between 350 to 356? Guys, look into these topics. These emergency is very important. You can expect a prelims question. Then similarly, Supreme Court, High Court, that also tribunal, these three also you look into. There is a possible question. Parliament, state legislature, there is 2 or 3 possible questions are there. Panchayat Raj institution, one question will be there. Whatever we have discussed, DPSP, fundamental rights, fundamental duty, preamble, and all 3-4 questions can come. So this is how generally they will make question. Then forget about the miscellaneous question. If you have that knowledge and the philosophy, if you know very clearly, then you will be in a position to answer. Otherwise, the questions which are asked from these topics, what are they? I'll quickly tell you. Preamble, never miss. Fundamental right, fundamental duty, Lakshmikant is enough, nothing else is required. DPs, okay. Then the president, vice president, council of ministers, parliament, state legislature, judiciary, that means Supreme Court, High Court. Okay, emergency, there is a question. Panchayat Raj institutions. Okay, then all these other bodies like election commission, finance commission, CAG. Okay, these three, put this into one category. One question you can expect here. Okay, so Panchayat Raj institution, one for sure you can expect. Judiciary, one can expect. National emergency, one you can expect. These area, 3 to 4 question you can expect. These area, 3 to 4 question you can expect. So this is, if you have that clarity, then things are going to be very easy for you. But if you get a question, you should not miss it. There is no need to go behind too much of text and things. You are sure that these are the questions which you can expect from these area. Do that very well. Any question you're getting from that, there is no point in missing it and cribbing it later. Don't do that. Okay, so 352, 356, I hope this is clear. 352, what about the rod of fundamental rights? I've told you this will affect the fundamental right. You can write it may affect the fundamental right. Why? Because if it is armed rebellion, may or may not, right? In case of war or external aggression, it will affect fundamental right 19. Then under 359, it can suspend the enforceability also. Here, no problem with fundamental rights, right? So here there is a parallel power on state list. Here there is the complete power with the state list. Now 360, financial emergency. Like if the president is again satisfied that the financial stability of India is under threat, then if he's satisfied with about such a threat, then he can he can impose financial emergency. Here also it has to be accepted within 2 months, similar to president rule, and then with simple majority. What about revocation? How can it be withdrawn? President can issue a revocation. Okay, that's it. And that revocation does not require parliamentary approval. In the previous case also, revocation does not require parliamentary approval, right? Okay. Next, we will see the president. Okay, so as I've told you, president is the executive head, right? If you see state legislature, not state legislature, the parliament, here this is the legislature and this is the executive body. So in fact, you can say president is the nominal executive and prime minister is the real executive, right? So president, any action on behalf of the state is actually taken on the name of president. Single transferable vote system, I cannot explain that now because that already have been explained and I've taken around 45 minutes to explain that. I think you were not there in the session. What I'll do is, those who have any doubt, I'll share you that video. That is the only thing that I can do. I will only refer to single transferable vote, guys, here in this session, because we had discussed about that proportional representation, single transferable vote, two ballot system. Okay, so everything else I can explain maybe in 2-3 minutes, but single transferable vote, if you remember, I have drawn a table and then I have explained. So that is going to take a lot of time. We cannot do that. If I do that, only this session will be completely with single transferable vote. And many others like you who are not attending that session will come up with a doubt also. I'll do one thing. I'll share that previous video. Okay. So where we were talking, what we are talking about? Yeah, president, right? So he is the executive head of the union and he is the highest constitutional functionary, and all the decision of the union which is taken actually in the name of president. Okay, so he is the first citizen of India and the supreme commander of armed forces. The point that we need to know is his executive powers, all the executive powers which are vested with the president that we have talked about. He is the head, all the powers are with him, but he can all these, even if you look into the judicial power, the executive power, legislative power, even the ordinance making, everything, guys, all these you need to look into the powers of president. Okay, if possible I'll discuss about this ordinance making and everything, but others in minute details, like what are the judicial power, what is respite, pardon, everything, that you need to look into, that can be asked. Don't leave anything for chances. When I told you these are the chapters that you need to look into, complete 100% from this chapter. Never leave anything for chances from this chapter. Okay, so he can only act according to the advice of the minister, the council of ministers. But what is more important here, we will look for the election of the president, right? So who all will participate? It is not directly elected by people, right? It will be an electoral college. So electoral college will consist of elected members of both the houses of parliament, elected members of both houses of parliament. But when it comes to vice president, elected and nominated. Guys, I'm not going to discuss vice president separately, so let's cover it here itself. So in case of president, elected members of both houses of parliament. Okay, but here elected and nominated members of both the houses of parliament. Apart from here, here that's it, only this, nothing more. Okay, but when it comes to president, who else will come? Elected. In case of president, all are elected. Okay, just remember that. Elected members of the legislative assemblies of the states. Okay, that means MLAs. And then also elected members of which two union territories? Delhi and Puducherry. Which amendment? 70th amendment. Okay, so look for that formula and everything. That is something which you need to look for. Value of vote of MLA will be equal to total population of the state divided by total number of elected members of the state legislative assembly. So total population, let's suppose n seats are there, then this is divided by n, and to then 1 by 1000. Okay, similarly, what about a value of vote of MP? In fact, a value of vote of MPs, if you see, it is actually equal to value of all MLAs. Vote value MPs equal to vote value of MLAs. Why? Because if you see, the value of vote of MP equal to total value of votes of all MLAs. What is that? What value of all MLAs? This part. Okay, so that will come here. I'm talking about value of vote of MP. Okay, divided by total number of elected members of parliament. Okay, N. So what I have told you here is actually total vote value of MPs. Now here what I'm getting, one vote value of MP. Yeah, I have told you only elected MLAs. What is the confusion? I've told that already. Here elected, MPs elected, MLAs elected, elected. I'm telling you how many times it is elected. What is the confusion? Okay, so here, what value of MLA we have discussed? Total population of the state divided by the number of seats. That means what, guys? Different state MLAs from different states will have a different value, right? From Kerala MLA and the UP MLA will have a different vote value. Here UP and Sikkim, if you compare, UP MLA will have a more say in the presidential voting, more value will be there. Now here, what I'm talking about, vote value of all MLAs. Guys, how many elected MLAs are there? You add each one of those, and what is the total that you're getting? That is what you mean by vote value of all MLAs. Okay, all MLAs who are contesting or participating in the election, their vote values I'm adding. So that is what here. If you need to calculate one MP's vote value, one MP's vote value. So vote value of all MLA divided by total MPs, total elected MPs. But what is written here? Total vote value of MP equal to vote value of all MLAs only. Why? Because here one MP, this N will go here. When N will go here, what you will get? Total how many MPs are there and vote value of one MP. That means total vote value of MPs, which will be equal to total vote value of MLAs. That means MLAs total if you take, MPs total if you take, that will be equal. Why it is done? To make the union and state at the same level when it comes to presidential election. Guys, those who didn't understood this at this point of time, please read Lakshmikant and you will be able to understand that. Okay, this one is not mentioned in Lakshmikant, but if you look into that formula, you will be able to understand that. Okay. So it will be like a proportional representation through single transferable vote, right? So single transferable vote because you will be given preferences, and it is also known as preferential voting. So there will be a quota which is fixed. You need to get beyond that quota. So that is why this single transferable vote system. So what will be done? Initially, you will be counting. You will be given first preference, second preference, third preference, like this. Okay, let's suppose there is a candidate A, B, C. So let's suppose you are voting, you are Q. You can give preferences 1, for A, first preference, second preference for B, third preference for C. Similarly, many other Q, R, S, etc. Many people will vote. Then what will be done? You will count how many first preferences votes are there. Now, there will be a quota which is fixed. If this quota is breaking, then that person is declared as the winner. If not, what will happen? The lowest member, the lowest one who got the first preference will go. Then his first preferences will be converted to others. Okay, so that's how it will be done till the time you get a final confirmation. And only one time in Indian history it has been done, second round of voting, in second round of counting, in which election, I think VV Giri, right? So only one time it has been done. So that's about president. Okay, guys, what we will do, we'll take a 10-minute break. Okay, and we will resume at 8:40. 8:40 we will resume. Okay, please take a break. We'll resume.